Good evening. Happy Sunday. Check this fucking freak out.
You think this is going to be easier for you, Merb? You got another thing coming, motherfucker. You want to mess with me and my family? You're definitely looking at some serious problems for yourself, ass fuck. Well, fuck yourself. All right.
Somebody is just a little bit ass mad. Somebody's just a little bit ass mad. That's just so beautiful.
You think this is going to be easier for you, Merb? You got another thing coming, motherfucker. You want to mess with me and my family? You're definitely looking at some serious problems for yourself, ass fuck. Well, fuck yourself. All right.
Oh my God. Does he understand what he looks like? Anyway, that's not what we're going to be dealing with today. Today, I've been traveling all weekend, so I apologize. I'm very tired, but I can't sleep right now. So I figured we would go through the response to the court's order to show cause regarding Doc 111. Oh. He's only gay for chili. So I hear. He might sue me for defamation. Oh no. But anyway, let's go through this. I saw it was only 6 pages, so let's bounce through it real quick. So remember the 3 things that the court was really concerned about, the 3 things that the district court was really concerned about. I apparently occupy his mind a lot, and there's a very fine line between love and hate. The district court wanted, what did they want? They wanted to know why judicial immunity doesn't apply, number 1. Number 2, they wanted to know why sovereign immunity didn't apply to the lawsuit against the 7th Judicial District Court itself. And yeah, I'm very, very concerned. And the third thing that the court wanted to know about was the court said, basically because he's suing for injunctive relief, Springer's suing for injunctive relief, the court wanted to know why causes of action 1 through 3 against the judges and the judges' staff, why they should not be dismissed for failure to state a claim. So let's go through this and figure it out. Reasons showing cause. At the onset, plaintiff wishes to emphasize that it is his deep concern that First Amendment rights should not mean less, nor violations of those civil rights should be excused more, merely because the persons and entity violating civil rights are part of the state judiciary. Well, that's the whole thing. The 42 USC 1983 gives the judges judicial immunity. So it actually does mean less because the entity violating the rights are part of the state judiciary. Plaintiff has raised the concern that this court is influenced by this external information previously in his motion, document 40, and because the court's sua sponte action here that goes beyond simply examining immunities as provided for in Hennessy and Andrews. These are the 2 cases that the court mentioned, just so that you all are aware. That is an excellent question, Script Cat, an excellent question. And if you ever find out the answer to it, I would like to know. I hate to break this to you, Script Cat, but Michael Eline likes to lie. What he did in that little video was a lie. He's a liar who lies. He lied when he said that I threatened his business and family. So yeah, that was a straight up lie. I mean, I'm a first year family law attorney. Like, what? Why the fuck would I even bother? I have been crushing him in this legal argument to the point where he is in a biker bar, live streaming and calling me names. That's how bad I fucking tore him a new asshole. Yes, he is a liar. He is a liar, Script Cat. Anyway, just for your edification, I did a quick bit of research on the 10th Circuit, and yes, the court does have the power to sua sponte raise these various issues. I did it when I was looking at the court's order to show cause, because I thought that was pretty cool. And yeah, the court has the authority to do it. But he says it goes beyond simply examining immunities. Hennessy allowed, what was it, Hennessy that allowed for the court to sua sponte raise the issue of sovereign immunity, and Andrews versus Heaton, I think, allowed the court to sua sponte raise the issue of judicial immunity, if I remember correctly. So yeah, I don't know why he thinks that it goes beyond those two. I guess because the court's doing both at once, maybe is his rationale. To address matters not raised by the defendants as part of their third motion to dismiss regarding individual capacity suits for injunctive relief under Section 1983 versus official capacity suits. He respectfully renews those concerns here. Well, so it wouldn't make a lot of sense for the court to issue an order, issue a judgment that's unenforceable. It wouldn't make any sense. So I can understand why the court would be allowed to sua sponte raise it. Namely, that the court is pressing into the realm of advocacy instead of neutrally arbitrating between the parties to the dispute, while having already shown a greater deference to the judicial defendants at the initial stages of this litigation. Again, I don't think the court was doing that. The court was showing to them what the court would have shown to anybody. Basically, you have to serve them correctly. It's kind of weird, but you have to serve them correctly. To reiterate, because obviously Springer's attorneys think that this judge is stupid, so he has to repeat himself. Plaintiff respectfully offers that this situation, a dispute between a private citizen and members of a state judiciary, requires more of the appearance of neutrality, not less, to maintain or restore public confidence in the judicial branches of government that may have been shaken here. Well, it's not, the court hasn't taken a side. The court has issued an order to show cause. The court has said basically, hey, what am I missing here? Here's your opportunity to tell me why you should be allowed to continue this suit. Because just on its face, if a first-year family law attorney out of California is screaming judicial immunity, as a judge, I need to ask about judicial immunity and sovereign immunity for the district court itself. Oh, and by the way, you're suing these people in their individual capacity. You can't ask for injunctive relief. So that's a problem too. Why don't you tell me how this works so that I can actually give you a judgment at the end that may be enforceable? Before addressing the court's concerns about immunities, plaintiff turns to the concerns of individual capacity suits versus official capacity suits for injunctive relief to stop violations of civil rights under Section 1983. To begin with, the court's point is well taken, but just as before, if the court wishes for amendment to correct the issue, plaintiff will absolutely oblige now that the court has placed the need for amendment squarely at issue. See, I don't think the court is asking him to amend his complaint. The court would say, hey, you need to amend your complaint. I think what the court is saying here is like, look, if you sue the judge in the judge's official capacity, the best you could do is get declaratory relief, but you're asking for injunctive relief. So official capacity suit isn't going to work for you. And if you sue them in their individual capacity, the best you can get is money damages, but money damages are expressly precluded by judicial immunity. So explain how you get money damages. So you can't sue them and get what you're asking for under either. You can't sue them in their individual capacity and get injunctive relief. You can't sue them in their official capacity and get injunctive relief. How is amendment even going to help you? I don't think the court's asking him to amend. I think he's trying to ask the court right here to amend. Best guess. Plaintiff is well aware that his claims against the 7th Judicial District Court, and more specifically the members, judges, or staff thereof, are proper defendants only for declaratory and injunctive relief pursuant to the Supreme Court's holding that. However, we have never held that judicial immunity absolutely insulates judges from declaratory or injunctive relief with respect to their judicial acts. The courts of appeal appear to be divided on the question of whether judicial immunity bars declaratory or injunctive relief. We have not addressed the question. Wait, we have not addressed the question? We need not decide whether judicial immunity would bar prospective relief, for we believe the Virginia court and its Chief Justice properly were held liable in their enforcement capacities. As already indicated, 5474 gives the Virginia court independent authority of its own to initiate proceedings against attorneys. For this reason, the Virginia court and its members were proper defendants in a suit for declaratory and injunctive relief, just as other enforcement officers and agencies were. Okay. All right. So they're suing the Virginia Supreme Court, but the Virginia Supreme Court has legislative power, so it would have legislative immunity. And they have enforcement authority. So I guess they would have, on a prosecutor. That would be the question. I don't care about attorney's fees, but okay. So legislative capacity, yeah. I know this case is cited a lot for the legislative capacity immunity. State legislators are immune from suit for making laws. The fucking statute itself does. That's what I'm not understanding. Oh, what year was that decided? What year was this decided? 1980. Okay. All right. Okay. What is this? Where's my normal one? Here we go. Reload. So this was the what is it? The Judicial Something Act. There was a Judicial Something Act. Congress passed a law that amended 42 USC 1983, and they added in that part. They added in that part. So they have Congress has come back in and said, no, you're doing this wrong, Supreme Court. You're doing this wrong. You can't get injunctive relief unless declaratory relief is not available or a declaratory decree was violated, right? So he's citing a case. He's citing a case that was decided before Congress passed that Judiciary Act, something like Judiciary Act of 1996, Judiciary Act 1996. Federal Courts Improvement Act of 1996, or something along those lines. That was something like Judiciary Act of 1996. It is the Federal Courts Improvement Act. Yeah. Anyway, so he cited a case. So Springer's attorney cited a case that was before 1983 was amended. So that's really stupid. That's a really stupid thing to do. Like, how can a really tired first-year family law attorney out of California figure that out in how long did it take me? How long have we been live? 17 minutes. In 17 minutes, I figured out that he cited a case. Well, maybe he has something else. So let's go on. Thus, because Mr. Springer is not suing because of a decision made in the case before the defendants, the Supreme Court has concluded that defendants here are proper defendants in their official capacity, and plaintiff will willingly amend his complaint to note that the individual defendants are sued for their actions taken in their official capacities for only declaratory and injunctive relief to halt the violations of his civil rights by these defendants. So injunctive relief, again, isn't available. It's just not. Like, I'm sorry. I know he cited a Supreme Court case, but he cited a Supreme Court case that was decided 16 years before the Congress said, hey, by the way, no, you only get injunctive relief if declaratory relief isn't available. So oopsie fucking doodles. Likewise, okay, so maybe he has something else. Likewise, the Supreme Court's decision noted above also appears to be dispositive of this court's concerns for judicial immunity. No, it's not, dude. Oh, how can you be this dumb? How can you be this dumb? Or am I missing something? Let me think. Am I missing something? I'm probably missing something. I'm probably missing something. He can't be that dumb. In the Supreme Court of Virginia, the Supreme Court addressed concerns about Virginia Supreme Court's regulation of the conduct of attorneys in that state. The Supreme Court, as noted in the cited passage above, found that regulation of the conduct of attorneys practicing before the Virginia courts, namely First Amendment advertising, was an enforcement action, not a judicial action qualifying for absolute judicial immunity. No. So in the Supreme Court of Virginia versus the Consumers Consumers Union of U.S. Inc., the Supreme Court found that the legislative branch of Virginia had basically given the Supreme Court of Virginia all of the legislative powers in making regulations for attorneys. So anything that they did to create rules, they would have judicial immunity for. Anything they did to adjudicate those rules, they would have judicial immunity for. But anything they would do to prosecute those rules, they would be susceptible to injunctive relief, just like a prosecutor would, because a prosecutor enforces the laws, and you don't want to have a prosecutor enforcing laws that are unconstitutional. That's what they held. They didn't say that basically anytime the Supreme Court promulgated new rules that they lost judicial immunity. They got legislative immunity because they're acting in a legislative capacity. Likewise here, but then again, this court, the court in the 7th Judicial District Court, didn't create regulations. They're not regulating anything. So I don't know why he's talking about this. Likewise here, the court has potentially identified, and defendants have alleged, that what animated the suppression of plaintiffs' rights to speech and press or administrative orders and exclusion from public hearing was the enforcement of decorum. First Amendment conduct of speech and press of private citizens appearing in defendants' courtrooms. Even if he's right about the enforcement mechanism, there is a difference between a court issuing an order to the general public and a court issuing an order about attorneys, because the court has inherent enforcement mechanisms against attorneys. The Supreme Court of your state can almost certainly disbar attorneys. Disbar. Yeah, you get an opportunity to be heard, right? The Supreme Court can say, if you're practicing in front of them, they can say, hey, you know what? I'm going to sanction you for this, or I'm going to do whatever. They can issue the sanctions, but because they control the keys to the kingdom for attorneys, you can't practice law without basically they're saying, yes, you have a license to practice. Then they have actual enforcement. But an order, like let's say you get a civil judgment against someone, the court isn't going to enforce the judgment. There's a whole part of the law called enforcing judgments. And like, say for example, I get a let's say that Michael Eline's wet dream comes true. He files a defamation lawsuit against me and he wins, right? So now he has a piece of paper in his hand. It's a judgment. His wet dream, right? He gets a judgment against me. Well, then what does he do? Now he has to enforce it. Now he has to figure out how to get the money from me, because the court's not just going to, like, the judge isn't going to come down off the bench and reach into my pocket, right? The court issues the judgment, but then it's going to be the sheriff, generally speaking, who would enforce the judgment. So you get a writ of attachment. You get a wage garnishment, something that the sheriff is going to enforce, because their law enforcement, things are named pretty much based on what you would expect, right? If something has enforcement in their name, they enforce the laws. If they're a judge, they issue judgments. So dogs are wanting attention because they've been gone. So you have to collect and watch out for the 34th Street shooters or spooters. Spooters. Nice. All right. Quit spinning me, dogs. Okay. So yeah, he's dumb and he's wrong. So if it worked the way he thought it was, every time the court issued a judgment every time the court issued an order. Every time, that would be enforcement. But it's obviously not, or else judicial immunity would have no meaning. Plus, again, he's he's citing a case that has been legislatively overturned, at least as far as that particular part is concerned. There's clearly no functional difference between the regulation of attorneys by members of the judiciary and the practice of law before the courts, and the enforcement, if that is the actual reason for the actions, versus ire towards the content of plaintiff's speech and reporting of rules of decorum on plaintiff here. Again, they don't enforce it. They issued an order. It is up to the sheriff and the bailiff, etc. It's up to law enforcement to enforce that order. Like if you get a restraining order, the judge doesn't come down and like make sure the bad person stays away from you. The judge gives you a piece of paper, and the sheriff or the police or the marshal or whoever, some law enforcement person, will enforce that piece of paper. Okay, I don't understand why it's so hard for Springer's attorneys to understand that. Moreover, the important distinction at play here of a suit for declaratory and injunctive relief versus absolute judicial immunity from suit for damages was stressed in the Supreme Court of Virginia, stating that adhering to the doctrine of Briley versus Fisher, an 1872 case, we have held that judges defending against 1983 actions enjoy absolute immunity from damages liability for acts performed in their judicial capacities. Absolutely. They still do. All you can get is declaratory relief. And if declaratory relief isn't available or they're ignoring it, then you can get injunctive relief. That's it. The Supreme Court's consideration on Stump versus Sparkman in Supreme Court of Virginia is also helpful here because it marks the extension of the law to more analogous facts in a suit seeking only declaratory injunctive relief in a more recent decision of the Supreme Court. Supreme Court of Virginia is good law that is not questioned by any subsequent decision of the Supreme Court or the 10th Circuit and supersedes the court-cited case. Well, 1983 itself has changed. 1983 itself has changed. I wonder, let's look up something here. Let's see what it says in Wikipedia, just for shits and grins. Wikipedia. Do they have it in Wikipedia? Wikipedia. Yeah. Well, they don't have the case exactly in Wikipedia. They have mentions to it. It is good law as far as the legislative immunity part is concerned. But the how do I get older versions of it? To be that. I just wonder what it looked like. prior. Well, you see right here, am I sharing? Yeah. Except in any action brought against a judicial officer for an act or omission taken in such. So this is what was added in 1996. So the act would have ended right before the except. So this part did not exist. So I don't think it's good law for what he's citing it for. Plaintiff here is not seeking damages under 1983 for the individual defendant's enforcement actions taken against him, i.e. excluding him from the building without chilling law enforcement escorts or excluding him from public hearings as punishment for an earlier minor violation of the rules requiring masking and prohibiting videotaping. Thus, based on the Supreme Court's clear holding in the Supreme Court of Virginia, defendants here are not entitled to absolute judicial immunity for their enforcement actions taken to infringe upon plaintiff's rights to speech and press, as the suit is limited to declaratory and injunctive relief. Again, I think he fails 100% on that. He may be entitled to declaratory relief, but he's definitely not entitled to injunctive relief. Finally, with regard to the court's concerns over 11th Amendment immunity for the 7th Judicial District Court, notably, the court's concerns are focused on the exception or waivers of the immunity under the New Mexico Tort Claims Act, but entirely misses the waiver of 11th Amendment immunity for violations of civil rights adopted by the legislature in 2021 in New Mexico Civil Rights Act. So, you know how I started second guessing myself just a few minutes ago, where I'm like, what am I missing? What does he know about this Supreme Court of Virginia case that I don't know? And I started second guessing myself. And I think it's a good thing if someone's like, hey, obviously, here's the thing, right? Here's the thing. You haven't accounted for it. You're a judge, you're a federal fucking district court judge, which means that you aren't stupid. You have law clerks who work for you, who can do research for you, and who generally you're going to keep around because they're intelligent and effective. To just assume that a judge is such a moron that like you miss something as blatantly obvious. Well, let's read what the court apparently missed. I just like, you entirely missed the waiver. Like, don't you think the court would have looked at the waiver? I'm guessing there's something in the waiver that doesn't actually waive it. Let's find out. The state shall not have sovereign immunity for itself or any public body within the state for claims brought pursuant to the New Mexico Civil Rights Act, and the public body or person acting on behalf of or color of or within the course and scope of authority of that public body provided pursuant to the New Mexico Civil Rights Act shall not assert sovereign immunity as a defense or bar to an action. What am I missing? Is that the entirety of it? So I'm going to guess. Where's the... 41-4A-9. Okay. What am I missing? What am I missing? I know I'm missing something. I've been through this before. This is what it is. This is what it is. I remember it now. So you have to present claims. No, that's not it. There was a statute in here. Because I saw it, because I remember talking about it. There's a statute in here that limits it. One. Aha. 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 That's the problem. That's the problem. I don't know why I read that last time and it just didn't even click to me, but that is the problem. Problem is, it has to be brought in a New Mexico district court. A New Mexico district court. Thus, Mr. Springer is a person who claims to have suffered a deprivation of any rights, privileges, or immunities pursuant to the Bill of Rights and the Constitution of New Mexico due to acts or omissions of a public body or person acting on behalf of or under color of or within the scope and authority of a public body, and he may maintain an action to establish liability and recover damages and equitable relief in any New Mexico. He even says it, in any New Mexico district court. Now you're going to say, well, isn't he in a New Mexico district court? No, he is in a federal district court. He's in the United States district court for the District of New Mexico. He is not in a New Mexico district court. A New Mexico district court is like a California Superior Court, or I think Texas does district courts, right? But yeah, so this is a state court. It has to be brought in a New Mexico district court. See how this action is brought against the 7th Judicial District Court? This is the 7th Judicial District Court is a New Mexico district court. So that's pretty dumb. New Mexico's waived sovereign immunity enshrined in the 11th Amendment, and this court, just like in Tort Claims Act claims, may exercise supplemental jurisdiction to hear those claims. I don't think so. I think because it has to be brought in a New Mexico under the very statute that he's citing, it has to be brought in a New Mexico district court. In fact, let's look it up. Let's do a little googly Google search on this bad boy. Just so I can do Scholar. And let's go back to here. We're going to go to select courts. We're going to clear all, and we're going to go to 10th Circuit Court of Appeals and the District of New Mexico. That's it. Just so you can see, I checked 10th Circuit Court of Appeals and the District of New Mexico. And we're going to go here and we're going to put in that bad boy right there. And here's the first one, 2023. Claims brought pursuant to the New Mexico Civil Rights Act must be brought exclusively against the public body. Interesting. So this one allows it to go through. This magistrate doesn't see an issue with it. Interesting. Maybe I'm wrong. See how easy that is, Mikey? Interesting. Why is it not showing up on that one? Inspect what you expect, right, boys and girls? So here's one, Maury versus Delaney. This one, it appears that the court says that they don't appear to have it. Appears they don't have it because the act provides a person. So two magistrates, these are magistrates' recommendations. So these two magistrates' recommendations are saying one way. This is a district judge, so it's above a magistrate. Oop, shiza. What did I did? Did I do Al versus Martin yet? This is a chief district judge. It stops talking about it. So this one didn't raise it or didn't address it. This is a memorandum opinion by a magistrate judge. Interesting. Let's see how it plays out, I guess. What is the name of our judge? What is the name of our judge? What is the name of our judge? This will tell me. Rizzoni. Wait, didn't I see one from Rizzoni? That might tell me something. That might tell me something. Rizzoni. Thought I saw Rizzoni. Why did I click on that twice? Magistrate judge. Okay. All right. So in this one, the court was just saying, like, hey, if you want to sue under this, this is the general thing that you've got to do. So the court wasn't saying that you can sue in district court over it. The court was just saying, generally speaking, here's the Federal Civil Rights Act and here's the New Mexico Civil Rights Act. Say, to inform the plaintiff's decision, the court provides the following general overview of the governing law. So I guess that really didn't help us much at all, did it? I still think he's going to have a bit of a problem, though, because the court raised the issue, and the court wouldn't raise the issue if the court didn't think that there was an issue there. So, and I think this part is really going to should be a problem, because if the state says, yeah, we'll waive sovereign immunity, but you have to sue us in state court, I think you have to sue them in state court. Anyway, we've come to the end, my friend. That was all of it. It is done. The New Mexico Civil Rights Act part is, I think, leans heavily against them, but I guess some courts still entertain it. Sovereign immunity, judicial immunity is, I think they lose hard on, and I think they lose on the injunctive part too. The individual, they would definitely have to. They could possibly get declaratory relief. They are not going to get injunctive relief, and they're not going to get damages. So anyway, let's see. I'm not quite ready to sign off yet. Let's see if anybody said anything interesting. Probably not, but we'll see. Show me the boots and look at my pick, please. So it's a lovely pick. It looks like a fat, what do they call them? A boot blister? Okay. Oof. Oof. Not a lot of love for Mikey in here. I think that's hilarious, by the way. Thank you, Redacted. Yes. Oh, I'm sure he does. But whatever. I mean, he gets to, it's his channel. He can do what he wants, right? That would be bad. That's what attorneys do. Attorneys file lawsuits for a career. That is also a correct statement. It is not defamation if true. Alrighty. Oh, I'll bore you. Trust me. I will bore you all the way. Yeah. I think Mikey. I mean, Mikey seems like he's pretty insecure. I'll be honest with you. Like, I'm surprised at how insecure he has seemed. I wouldn't expect. Like, I've had people challenge my legal views before. Like, I never went to a biker bar and like made a mad ranting video about them. It's just like, it's so gay. Like, what the fuck is wrong with you, bro? What the fuck is wrong with you? Well, Jeff Gray is the gold standard with audit. Jeff said I could cover a video he did. He does his combinations. Like he'll get like the police body cam footage. He'll get the 911 calls and stuff. Anyway, he had one. He was standing I think he was standing in a parking lot filming a police stop from like probably like 20, 25 feet away. A couple of cops pulled up and they're like, hey, you're bugging him. Go stand by the building. So basically go further onto the property. And then they went inside and talked to the property owner or person with apparent authority who trespassed him. And so they're like, okay, get off the property. And he's like, all right. And he starts walking off the property. They're like, no, go back, get your vehicle and get off the property. He's like, no, I'll just get off the property. And he walks off the property. And they're like, well, no, fuck you. And they arrest him. They arrested him off the property for trespassing. They told him to leave the property. He left the property. And then they arrested him because he left his vehicle at the property. Which is really fucking weird. Anyway, he sued him. And they looked stupid on the stand. But no one even tried to say that they didn't have the authority to, or they didn't they weren't allowed to go and ask the property owner if they could be trespassed. The problem was they arrested him after he stopped trespassing. They said, get off the property. And he left the property. But he didn't leave the property like they wanted him to. It was dumb. Wasn't there a period of absolute immunity based on new legislation? Not that I'm like judicial immunity has been around since the beginning, basically. It was codified in that, was that Fisher, I think is the name of the, whatever it was. Oh shit, I didn't go over whatever. I've been on the wrong goddamn thing forever. Oh, but since you're here.
Do you think this is going to be easier for you, Merb? You got another thing coming, motherfucker. You want to mess with me and my family? You're definitely looking at some serious problems for yourself, ass fuck. Well, fuck yourself.
So scary. Right. So scary. You scare me, Michael. You scare me.
This is going to be easier for you, Merb? You got another thing coming, motherfucker. You want to mess with me and my family? You're definitely looking at some serious problems for yourself, ass fuck. Well, fuck yourself. All right. You think
Internet tough guy. If we're discussing Virginia law, why are we looking at a New Mexico site? The case, the Supreme Court of Virginia versus blah, 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 was a United States Supreme Court case. Well, hello. Okay. That's crazy talk. Just for filming the police? Crazy talk. I actually haven't watched it. Somebody just posted I know Josh did a stream on. I caught like 10 seconds of it, but I haven't watched it yet. Someone just posted it in my Discord. I guess I am. Let me see. I will find the video. I will find that video. Let's see. YouTube Studio. Let's see. Go to content. Which one is it? I think it's somewhere in here, maybe. My voice went really high there. Let's see. Here we go.
You have unlimited authority to make requests or demands on that day, on October 23rd, 2013. Did you have unbounded, unlimited authority to make requests and demands of Mr. Gray such that Mr. Gray's refusal to comply or acquiesce with such request or demand would subject him to arrest, could subject him to arrest for resisting or disobeying you.
Yes. What? I mean, detained or anything?
I don't detained. You made
Yeah,
yourself part of this traffic stop.
Okay, I'm observing practice.
Who are you?
I'm a journalist gathering content for story.
Sorry?
Journalist gathering content for story.
For a story? What kind of story?
The story I'm working on.
What's the name of your story? What company do you work for?
Obviously.
What's your name? Oh, I see. You're one of those kind of guys. Okay. Well, do me a favor. Stand over here in the shade.
Right.
But don't stand behind this deputy while it's
That's why I'm standing more over there. Because
Well, actually, you are, sir. So stand over there, like I asked you, so you're not behind this deputy while it's
Stand over here.
Thank you.
Yes, sir.
Now you're trespassing, so they want you to leave.
Okay, you got heard trespassing. Is that what you're saying?
I'm not asking you. I'm not going to argue
That's fine,
with you.
I'm
I'm telling you, leave and leave right now.
Leave and leave. You can change badges further.
Leave and leave right now.
Thank you, change badges.
No, sir. Leave and leave right now.
So he's left the property.
I'll tell my wife to move it. I'm over here on the public right away.
On your back.
So they arrested him on the right of way after he left. So that was pretty fucking stupid. But anyway, yeah, that's a Jeff Gray video. Yeah, Jeff Gray didn't do anything wrong there. Gay Stachio? Oh, Josh. Josh's name is Gay Stachio. Is it Gay Stash? Anyway, it's after 10 o'clock. I'm going to see if I can't go to bed. Thanks for watching. Have a good night.